All right, after a technical difficulty there, I guess we'll resume with part 2 of chapter 4. Just about done with this chapter. So if you didn't get it at the end of part 1 there, the other civil claims include confidentiality and defamation as well, and defamation can be considered slander or libel. Slander is spoken, libel is written. High-risk situations in which you may find yourself into some legal trouble include things such as medication errors, and that becomes obviously a big issue now that you're an AEMT, and that's why that med math becomes ever so important. Dropping or improper handling of a patient happens from time to time. So let's say we are rolling our cot along the sidewalk, one of the wheels drops off the sidewalk, we're not paying close attention, the cot tips over. Or we go to lift the patient in the ambulance and we drop them. Emergency vehicle collisions, that's probably one of the big ones, as well as physical restraint issues. If you're restraining a patient, and those patients that are being transported beyond their will. So think about it, Rob's on his way home from work, he has changed out his uniform, is outside his jurisdiction, and he's in another district. En route, he witnesses a motor vehicle collision. He's decided not to stop and help. What ethical and legal issues does he face? He's outside his jurisdiction, he's off duty, he's not in uniform. He really legally does not have a duty to act here. Ethically, though, he may struggle with this, and other people may struggle with this, that he knows what to do, he really should stop and render aid. So legally, he's probably in the clear. Ethically, it's a decision that he has to make. So some other criminal law issues, such as HIPAA. HIPAA is the Health Information Portability Act, and HIPAA really does not. It's a confidentiality thing, but in reality, a majority of HIPAA actually has to do with the transmission of patient data in an electric format or storage in electric format. So it is really not as much the patient confidentiality issue. There occasionally we run into people in nursing homes or hospitals that don't want to give us information because they say it's a violation of HIPAA and their private health information or patient health information. And in reality, they're required to pass that on because it's required to continue patient care. So information can be shared if the patient consents in writing, and this may include spouses. You know, a husband can't go get his wife's information if she can't either A, give permission, or B, there isn't some sort of an agreement already in place, a written order or whatnot. As an advanced EMT, it is not your duty to provide this information. You don't give this. You have policies and procedures for your service if somebody's asking for it. Information can be shared without the patient's written consent to other medical providers who have a need to know, hospitals, and then those caregivers that are going to continue care. Information can be released for a court order. The court orders it. There's no reason that the patient has to sign off on it. Again, if somebody shows up at your door, an attorney shows up at your door and says, you have to give me this, you turn that over to your management of your service and let them handle it. Information can be released for billing purposes. So to authorized insurance companies, certain pieces of information can be relayed to them so they will pay the bill. Usually there's an authorization form that services will use, have the patient sign and say it's okay to release info to my insurance. And then patients are permitted by law the right to inspect their own. So if they want to come in and look at their own record, they can. So EMTALA, on the other hand, we mentioned that earlier, but EMTALA is the patient's right to approve and disapprove of any transfers, as well as requiring appropriate contact be made between different facilities. And COBRA is the Consolidated Omnibus Budget Reconciliation Act, or the anti-dumping statute. So that helped prevent patients from getting shipped off to another health institution without their permission. So under what circumstances does HIPAA allow protected health information to be shared, and with whom? We just discussed that, so I'll let you cover that one. So some legal protections. A few things that come to mind here when we talk legal protections. You need to understand and adhere to your standard of care. Doing things rogue, doing things off label can get you into trouble quickly. So you have to be very, very cautious that you stay within the bounds and your protocols. Exercise due diligence in all activities. Give it good thought and have a good reason to do it. Just because we can do something doesn't mean we should. We need to be able to back up what we're doing and have a good reason. Act within good faith. Do what's best for your patients. And then be professional. Be professional in your appearance and your actions, because people are seeing you not acting as a professional. They're going to question your competency, and all the more reason why they would potentially not trust you. So, additional legal protections. Good Samaritan. In reality, Good Samaritan law does not apply to EMS professionals or any other licensed provider. Good Samaritan is for those people who are just acting within good faith. So perhaps if we go back to that a couple slides ago when it talked about the Rob on his way home from work out of his jurisdiction, should he stop and help, he may be covered under a Good Samaritan law if he just simply does minimal life-saving things and acts within good faith, doesn't expect any remuneration for it. In most cases, then Good Samaritan may apply. When you are on duty, when you are performing your duties as you are hired to do and licensed to do, you are not covered under the Good Samaritan laws. You may have some governmental immunities if you're a governmental agent, but in most cases those don't really protect you much either when it comes to health care. Statutes of limitations. Statutes of limitations does put an end to a specific time after an action has occurred that they can no longer pursue it. And those vary from state to state. A lot of times it's somewhere around 4 or 5, 6, 7 years is where statute of limitations will end for certain things. Some things there are no statutes of limitations, such as murder. And then documentation. So back yourself up. Good documentation tells the entire story, paints a very clean picture of what's happened, and it gives you the best defense and the best backup should it ever be questioned. All right, so another think about it here. James arrives for the start of his shift. His manager asks him to come into his office. We just received a notice that the widow of a patient you treated is suing us for wrongful death. James calls an attorney recommended by his coworker. How would you handle this situation? That's probably exactly what you ought to be doing, is contacting an attorney. And you keep your mouth shut. You don't talk to other people outside of the attorney that's representing you or the direct management involved with your company. Crime scenes. I've talked occasionally about crime scenes. Crime scenes, you must remember to protect yourself because they often are still dangerous scenes and a lot of unknowns involved with crime scenes. Of course, patient care remains your priority. That's what we're there to do. Do not destroy evidence. So if you have a hanging patient, don't cut through the knot. If you have a shooting or stabbing, don't cut right through the hole from where the bullet or the knife went. Try to preserve that as best as possible. Don't move stuff if you don't have to. Try to take the same path in and out, and if possible, don't take the beaten path. So walk along the walls as opposed to right down the middle of the hallway. Walking right down the middle of the hallway, if there's any footprints or any other trace evidence, you walking right down the middle of it can damage it or destroy it. So try to limit your impact there. It's kind of like low impact or no impact camping. Leave as little trace of what that you were even there. Use the minimum number of providers. So if you respond with an engine company, you probably don't need all 6 or 7 people running into the house on many crime scenes. Now, if the patient's critical, of course, law enforcement would want you to do what you can to keep the patient alive, because that's their best resource to get information is from the patient. But if the patient's already deceased, they much rather need the physical evidence they're going to find. So avoid cutting through holes. If they're dead, don't enter the crime scene unless you're asked to come in and verify it. And in those cases, one person probably needs to do that. Notify law enforcement if you move or touch or take anything. And it'd be best to ask them before you do this. And then document, document, document. You need to paint the picture here, because there's a chance you're going to get called into court on it as well, just to be a witness. You're not going to be probably charged. It's more likely you're going to just be a witness. So you and your partner respond to a shooting. You stage nearby and request clearance to enter the scene. Dispatch tells you to go ahead. And as you pull into the location, gunshots ring out ahead of you and to the right. So what do you do with it? You get the heck out of there. If the scene has become unsafe, you move along. So get out of there and wait for it to become cleared and safe again. And you may want to talk directly to a law enforcement officer who is on scene, as opposed to having it relayed through dispatch. Other legal things that can potentially pop up: organ donation. Depending on the state, you may be part of the process that might start the ball rolling. We don't always have a huge impact in this area, but we may be able to talk to people and find out if the person was an organ donor or wanted to be or would have wanted to be, and notifying the hospitals, hey, we have this situation that this person is most likely not going to make it, but they're an organ donor. It kind of starts that ball rolling. Know what your laws are in your area. Lancaster County, Nebraska, which is Lincoln, for example, has a very tight EMS system there when it comes to what they're allowed to do, what they're not allowed to do, the field training process. And in other areas, it's very loose, it's very open. So you got to know what your local system is. Mandatory reporting laws. Abuse. You have to report suspected child or dependent adult abuse. You have a 24 hours to make a verbal report, and 48 hours to file a written report. Other things that you may have to report. Anything that's a criminal offense, law enforcement needs to be notified of. All patients are legally entitled to the same standard of care. If you alter your standard of care for one person, you are violating their civil rights. And then remember, you are a borrowed servant. You don't operate on your own. You operate under that of your physician medical director. So the borrowed servant doctrine can be an issue in some instances of negligence, because your negligence alone is passed on to others, your physician medical director, potentially your service and whatnot. All right, that goes back to your original think about it. Now in our chapter summary. AEMTs operate within the legal and ethical structure, such as things as authorization to practice, consent, standards of care, confidentiality, and due diligence. We also have to be aware of our legal and ethical obligations, apply good judgment, avoid claims of assault, battery, false imprisonment, or abandonment, protect yourself from liability, and do an excellent job of documenting. To establish negligence, you have to prove duty to act, breach of duty, harm or injury, and that there was proximate cause or causation that links them all together. All right.